Court is calling 2018 CR. All right, if you all could not talk behind the court reporter, please. Just move it towards the end. Court is calling 2018 CR 10107, State of Texas versus Priscilla Amaya. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Lorraine
Okay.
Easter for Miss Amaya.
And are you Ms. Amaya?
Yes, ma'am.
Showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, I did.
Are you the same Priscilla Amaya who was placed on deferred adjudication in 2018 CR 10107 for the offense of possession of a controlled substance, penalty group 1 less than 1 gram on June 28, 2019 for a period of 3 years? Is that you?
Yes, again.
State?
Yes, Your Honor. Violated condition number 5 in Bear County, Texas. The defendant Priscilla Amaya did then and there fail to report to the supervision officer as directed for the months of November, December 2021 in violation of condition number 5.
How do you plead to that? True or not true?
Sure.
We'll waive the remaining violating conditions, Your Honor.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, Your Honor.
Court will find violation of condition number 5 true. Is there an agreement?
Yes, there is, Your Honor.
Yes.
This for adjudicate guilt, revoke the provision, and sentence the individual to 11 months in the state jail facility.
No objection, Judge. That's our agreement.
All right, Ms. Amaya, are you asking the court to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, so what went wrong with you?
To be honest with you, Your Honor, well, I relapsed and I didn't want to report. I thought working was good enough, but I didn't have my family intact, my kids all together. They were disappointed in me, so they stopped talking to me. But now
I'm sorry, can you speak up?
now I have my kids back in my life and I have my first grandbaby, so I see things different. I know I do need help. And I'm willing to take that help as an outpatient when I get out of Bear County Jail.
Here's the thing. If you want to remain on deferred adjudication, I will let you remain on deferred adjudication. But you're going into inpatient treatment or either you're going to felony drug court. Now, you say, oh, I want to do my time, I will get out and I will take care of things and I will be clean and sober. 9 times out of 10, that's not going to happen. You know why? Because you are looking at 2 years in the state jail facility and you couldn't do it. And you are a person who should not be around your grandchildren or your children because you don't have control of your addictions. You're using opiates. You need help. So if you want, here are your 2 choices. State and defense, they came up with their agreement. Here's your choice. 1, you can be referred to felony drug court. If felony drug court accepts you, great. If they don't, you go into inpatient treatment. Or you can go to the state jail facility for 18 months. Either way, your life, the time is going to pass. Either it's going to pass with you bettering yourself by taking care of your drug addictions, or either it's going to pass with you marking days off the calendar, just doing your time at the state jail facility. So which do you prefer? 18 months at the state jail facility, or perhaps getting treatment for your drug addiction, being the type of grandmother that your grandchildren can be proud of and that your children can be proud of? It's completely up to you.
Yes. May we have a minute, Your Honor?
Yes. Yes. Jason, these are difficult choices that people have to make. Prison or treatment?
I totally agree with that.
All right, while she's thinking about that, are we ready on Mr. Miles? Are we ready on Amaya, or are you still discussing?
We're ready, Your Honor.
All right. So we're back on the record. In 2018 CR 10107, State of Texas versus Priscilla Amaya. So, Ms. Amaya, have you had a chance to discuss things with your attorney?
Yes, Your Honor.
So which do you prefer?
Your Honor, we're going to take the state jail time, but we are requesting that the court, if the court has the ability to refer or recommend her to a therapeutic community there for drug treatment, we are requesting that.
All right, then the
I-
court.
I think that will allow her to get some credit for her time at state jail.
All right, is she waiving her right to appeal then or no?
Yes, Your Honor.
All right, then the court will find you guilty. The court will grant the motion, sentence you to 18 months in the state jail facility, give you credit for any time served, and the court will recommend the therapeutic community. Therapeutic community will not increase the amount of time that you're in custody, but I do not have the authority to have them place you in there. The only thing I can do is request and recommend it, but you're also going to have to ask for it. You understand?
Yes, sir.
All right, I'm showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement,
Well, not
Well,
actually.
she's waived her right to appeal.
Okay, that's right.
Yes.
You're right.
Thank you. And you've waived your right to appeal. You do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. How old are you?
I'm 40.
All right, you're 40. You still have a lot of your life in front of you, and you need to make a decision. And I know staying clean and sober is hard. And this is from somebody who's never done drugs, but I understand it's hard based upon my experience in different treatment courts and based upon the fact that I'm having a struggle giving up ice cream. And ice cream is not even as addicting as the drugs that you're taking. But if you don't stop, one or two things are going to happen. Either you're going to continue going in and out of the prison, or either you may end up with a bad batch and you may end up overdosing. And I don't think you want your children or your grandchildren to read about you in the news where it's bodies found on whatever street it is. And then they finally identify it and it's you. You understand? But you're going to have to work for it. And when you get out, there are plenty of places that have free treatment for you. Okay.
Yes, Your Honor.
All right. Good luck to you.
Thank you.
You're welcome.
Thank you, Judge.
Thank you. All right.
Court will accept the defendant's pleas of no contest to counts 2, 3, 4, and 5. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
July 11th at 11 a.m. with Judge Barr.
July 11th. Well, when is the other case set?
June 28th, Your Honor.
July 11th, 2023 at
11 a.m.
11 a.m. before Judge Barr.
Your Honor, may we address bond, please?
You may.
Your Honor, in speaking to Ms. Woods, she's indicated that she has had continuing involvement with community mental health. Mr. Meyer from our office has been very involved with working with community mental health. It's my understanding that should she be released today, I believe this is the only matter holding her, that community mental health will be working with her, that they will be providing housing for her at a hotel in this area, and that they will also get her a medication review appointment, as well as to make sure she receives a shot shortly thereafter. So they have a plan for her housing, for her medication. And in addition to that, she will also have a peer support specialist. They also indicated that they would, that they would be able to assist with making sure that she appeared for Zoom for the 28th for that court hearing before Judge Barr and with future court hearings and other requirements.
Is all of that in writing somewhere?
I had asked for a separate email string. It is on the email string with myself, Mr. Feaster, and Mr. Meyer with several other emails.
Gotcha. But is there
not received
something
anything
from,
separate.
is there something from CMH? You're
It-
saying
it-
that is on
it
that
is-
email string?
Yes, it's from David Gilbreth. David Gilbreth is the one who said that he would take her to the medication review and would be submitting the documentation for her to stay at the hotel, and who indicated there was a peer support specialist and a prescriber for her shot. It was Tia Watson who indicated that who asked for the Zoom information and that she would be supportive of be supportive of Miss Woods in terms of appearing on the 28th. It's over the course of several email strings between us. I did invite them to either come or to send me something that I could provide for you separately. But this is what I have.
I understand that. And quite frankly, I don't necessarily have an objection, but I'd like something for myself. If I were making this decision, I want to make sure that I see something in writing, particularly regarding the housing and the medication structure. So what I'm going to do at this time, without the need for a response, is I'm going to deny the motion for bond reduction. Her bond will continue. I would suggest then that you can bring all of these matters up before Judge Barr on the hearing that he is having on the 29th and get that information to him.
So, no bond for me, Your Honor?
Well, no, that's not what I've said. What I've said is I'm leaving your bond where it is right now. On the 28th, when the other pleas are entered, they'll have the documentation before Judge Barr, he will be the one handling your sentencing. So all the information will be before him. And I believe that he's appropriate.
I have one more question. Is there any way you can make it 1,000, 10% instead of 10,000, 10%?
I'm not changing anything at this particular point in time.
Okay.
Exactly what I'm gonna do. Ms. Gaines understands what I think she needs to certainly get before Judge Barr, so that they have something that's structured. All right, thank you.
So I see you again, Your Honor. I won't be able to get out to July 11th.
I'm sorry.
I won't be able to leave till July 11th.
I would hope that you'd be able to resolve all of these on the 28th.
Okay.
And I'll be
Thank
sure
you.
to let Mr. Meyer know, Miss Woods, so that he'll be able to have that case available on the 28th.
All right, thank you.
All right.
Court calls the case, People versus Thomas Vasher.
Name Ishkanatra, First Assistant Prosecuting Attorney for the People.
Zachary Ward on behalf of Mr. Vasher. Mr. Vasher, can you please state your name?
Thomas Vasher, V as in Victor, ASHER.
Your Honor, I have reached out to the people about a potential referral to drug court in this case. I haven't heard back, so I'd be requesting a judge to see if that's possible and get the referral paperwork to the court if it is.
July 6th. Oh, go ahead, I'm sorry.
Your Honor, no objection. I would also let Mr. Ward know there's a pending warrant request for destruction of property, police property in R&O with this defendant.
Okay. Do we think that'll be arraigned by the 6th, or would it make sense to go out further?
There'll probably be a charging decision by then.
Okay. Your Honor, and then I would also like to address bond.
Okay, go ahead. July 6th, 9 a.m. Go ahead with.
Your Honor, Mr. Vasher is presently being held on a $10,000 cash or surety bond in 22 FB 1349. That was the result of a bench warrant back in October. However, Mr. Vasher did spend some of the time when not before the court in treatment. In Life Challenge Ministries in Detroit. He believes he's eligible to return to that program. He also has full-time employment in the community, as well as a lease that he is currently $1,200 behind on, and is hoping the court could consider reducing the bond to allow him to keep his housing situation and continue with treatment.
But where was he between the time of the bench warrant and the time he came into custody?
Your Honor, I can't account for all that time. He does report that some of that time was spent in treatment, but I haven't been able to verify the exact dates as of yet.
And did he turn himself in or he get picked up?
I believe he got picked up, Your Honor.
I
don't need it.
did get picked up, Your Honor. I did get picked up, but I mean, like, honestly, like, I was scared, honestly, to come in and turn myself in. I'm just gonna be 100. I was scared because I had a warrant and I didn't want to go to jail and lose a job, which I had, and I was paying rent. I was scared. It wasn't that I didn't want to get everything done and done right. It was that I was running off of old fears in the original life experiences of being incarcerated over and over and over again by actions of myself. And I was scared. I mean, but I have a 5-year-old son that I really just met. I've been in his life only for 2 weeks. I'm trying everything I can. I have a job and I have rent, and I really, really need this in the worst way. And I will do everything that is ordered of me. And
Except come to court.
No, I will come to court. I will come to court.
Yeah, you didn't the last time.
I went to the treatment, and when I left treatment, I was scared because I had the warrant. So I didn't come to turn myself in because I was scared. I was literally scared. I'm not that person. Literally, I have a child and I want to do better.
Mr. Vasher, I think the judge has heard you now. I don't think.
All right, I really do.
Motion for bond reduction denied. Additionally, he didn't turn himself in. He had to get picked up on these. There was a significant period of time that passed, so the court would consider him a flight risk. Additionally, it appears that there may be more charges coming against this defendant. Bond will continue. Thank you. Court calls the case. Verse. Court does call the case People versus Mark Austin.
Hey, I went to U of M hospital. They forwarded some documentations talking about manipulation of the body.
Alec Travelowski on behalf of
After
People.
I left this hospital,
Assistant Public Defender
I ended up going
Calvin
to,
Hawthorne on behalf of Mr. Mark
I
Austin.
ended up going to Ascension. No, I ended up going back to this hospital because I left without even getting discharged once I seen these documents.
Okay, can you state your name?
Of the body.
State your name.
After manipulation, after I seen the documents, it said manipulation of the body.
Mr.
I
Austin.
ended up leaving the
So
hospital.
that's Mr. Austin.
I was discharged.
Okay, and so what are we
I ended up leaving the
doing?
hospital.
Your Honor, we are requesting
I
a
didn't even get
2-week
discharged.
adjournment. Mr. Austin is up for a review on competency a week from today. We would like to see how that plays out. And we also need to review the discovery with him.
He's up for review on competency. That's not what we're here for today, is it?
No, it is not. For a separate case, Your Honor. I apologize.
All right, so when's that review happening?
June 29th.
All right. Then what I will do is I'll adjourn these over. Hopefully that review will take place. And I'll set this for the 6th, July 6th, 2023, 9 a.m. Bond in these matters will continue. Thank you.
and as it relates to the blocking traffic, or as it relates to the failure to stop, will you stipulate to the face of the ticket as an act of factual basis for that responsible plea?
Yes, Your Honor.
All right, with that stipulation, I'm gonna find you guilty, strike that, I'm gonna find you responsible for the amended count of blocking traffic. That does not abstract either, it's just a civil infraction, $175, stipulation of probable cause, I'll dismiss the other matter.
So stipulate.
Miss Love Turner, $175, $240, I'll waive the warrant fees, when can you pay it now?
I need some time on here.
How much time you need?
That's all for me. I just need like, yeah, and then it'll be paid. I know how to do it in the kiosk machine and stuff.
I'm gonna give you 30 days. Make sure it's paid. Come back on July 24th, 2023. If it's paid, we'll dismiss and close the matters out. All right, Ms. Love Turner?
Yes, you said the 24th.
Yep, July 24th. If there's nothing further, ma'am, you have a very good day. Best of luck to you, okay?
Thank you. What time? Same
At
time?
8:25.
8:25. Thank you.
If paid, you don't have to show back up.
Oh, well, it's gonna be paid then. So
All right, well, we'll see. If you don't pay it, I'm gonna put a warrant.
I paid.
On for you.
Hey, look, I ain't never been in trouble in my life. I paid it last time, so I bet you this be paid, and I ain't even got no job. I'm really disabled. I had a knee replacement.
All right. I hope you get better on your hip replacement, ma'am. Best of luck to you. We'll dismiss it if it's paid. All right. Have a great day.
Thank you. You too.
All right. Thank you. Jeffrey, this is the city of Detroit versus Jeffrey Lamont Gill Jr. Case number SP 142733101, SP 1427561. Appearance for the record, please.
Bill Walling representing Mr. Gill. State your name, sir.
Jeffrey Gill.
Mr. Gill, good morning to you. Do you have valid insurance for this vehicle?
Yes, I do.
All right, let's see what you have, sir.
I had sent it to the email that was provided, but I can bring it up on my other phone.
All right, let's see if you sent it to the email that was provided. Where was the email provided? That was that 434 email?
434. The last court date, she gave me an email to send the paperwork through. I guess so the process can go a little faster.
All right, let's see if we have that paperwork in the file. I don't have it in the file. We have all right, if it is, did you take these tents off these windows, or do you have tents on the window?
No, I haven't got a chance to take them off yet.
Well, you want to, hey, 100, if you have the insurance, he said he sent the insurance to the email address.
I have the policy on my phone here too. I don't know if you can see it or not.
Let's see what you have. You have to turn the background off, sir.
Oh, okay, 1 second.
Let's see. All right, I'm satisfied with that. Pay $125 for this tenant windows.
Yes, sir.
Want to take the deal? I'll dismiss the other case.
Okay, yeah, I'll take it.
That's what they call the cost of doing business. You know, I know everybody likes the tents, but it is. I just saw on the news today. Go ahead.
Not everyone likes the tents, Your Honor. From a purely safety point of view, I can't make eye contact with the other driver. Second of all, I personally, in this day and age, don't want to hype up a situation with the police department because you got tinted windows. They're already hyped up walking to your car. So for your safety and your fellow driver's safety, you please get that off of your windows. Please proceed to sentencing, Your Honor.
Well, it's not sentencing because it's just a civil infraction. It'll just be defined. You admit to the thing. But what I was gonna say was, I should have clarified myself. Everybody that has the tents likes the tents because it does look nice on the vehicle. But I was looking at the news this morning, and in the city of Ann Arbor, they said that they're gonna stop pulling people over for expired plates, tinted windows, and little nuances like that in an effort to, because it's a lot of times
And I don't blame the
it is
police.
a racial disparity. Pardon me?
And I don't blame the police department and their union one bit. And that.
Well, maybe not. That's just what the news said. All right, Mr. Gill, $120. When can you pay it? I'll dismiss the other matter for provided valid documentation. When can you pay the 120?
Is it possible I can get up to 30 days to pay it?
30 days. 30 days. You got a work shirt on. You driving a brand new car.
Yeah, I gotta catch up on some bills. I mean, it's gonna be paid before 30 days. It just give me some wiggle room.
7/24/2023. You don't have to come back. If you pay it, pay it. If you don't, it's gonna probably affect your license, and it's gonna be late fees and all that stuff. Nothing further, sir. Have a very good day. Best of luck to you. All right.
You too. Thank you. Appreciate it.
I got some people, some officers in the breakout. Gas away. Gas away. Gas away is not on the docket. I've seen gas away. Oh, she is. Maybe this is not the same gas away. There's a lot of gas aways in the city of Detroit.
Really?
Yes, it is.
This is Tanisha.
You got a lot of cousins out there, Miss Gasaway. All right. City of Detroit versus Tanisha Rachel Gasaway. Case number SP 140-35381, SP 142-9912, counts 1 and counts 2. Appearance for the record, please.
Paul Faulkner representing defendant. Can you unmute yourself, Ms. Gasaway, and give us your name?
Unmute yourself, man. Ms. Gasaway?
Oh, I was on mute. I'm sorry.
Got a whole lot of tattoos, a whole lot of skin there showing, man. This is court.
Sorry.
You gotta tighten it up a little bit.
I ain't used to court.
I know, that's why you need to put on a little something, you know, that's not showing so much skin, man.
Sorry.
So can you get a shirt or something on there, please?
Yes.
And then if you have it, grab the valid registration and insurance.
Yes.
Shirt first, though, please.
I do have on clothes.
Let's see.